Good afternoon, ladies and gentlemen. This is Chip Morrison. I'll be presenting a webinar today on the Mandates Amendment. I'm going to go for about 45 minutes, and then at the end we'll have time for questions and answers. You'll be able to write your question down, and we'll pick it up here and try to answer it if we can. As I said, today's also following the webinar, there will be a written my written presentation will be on the website, as will the PowerPoint presentation that we go through today. As I said, this is on mandates, state mandates. How many of you have gone over to your neighbor's house, gave them a book of signed blank checks, and said, "Your life's on me"? Or maybe you've gone next door and given them a credit card with a $30,000 limit and said, you know, have a ball, it's all on me. I guess nobody's raising their hand, but that's what the state legislature does, and that's what the Mandates Amendment was designed to prevent. Simply speaking, if the local government's elected officials are going to raise taxes, then the money should be paid. Then the money should be used for local projects, not state priorities. If the state legislature feels like that a cause is noble enough for them to pass a statewide policy, then they should pay for it. And so that is the entire purpose behind the Mandates Amendment. I'm going to be talking today. I'm going to talk a little bit about the events that led to its passage. I'm going to also talk a little bit about what the mandate says, and more importantly, what it doesn't say. I'm also going to talk about some issues that we see day in and day out because of the mandates, as well as talk a little bit about how it might be improved and how to go about doing that. We really never had much trouble with mandates up until about the mid-'70s, when they kind of became prevalent. It kind of began. If you look at your history, you'll see that legislatures in general became more active in the late 60s and early 70s and on into the 70s. City officials were getting frustrated with the unfunded mandates that the state was passing, and so they asked the legislature to pass a law. So in 1978, Florida's legislature passed a state law that said that they would no longer pass unfunded mandates on the local government. It said that any unfunded mandate would accompany a financial impact statement, and they would provide a means to fund. Then in the next 10 years, then in the next 10 years, they decided they promptly ignored it. Excuse me, just one moment. The reason they could do that, most of you have heard phrases like a future legislature cannot bind a previous legislature, or you've heard case law to the effect that a later enacted statute prevails over a previous statute. Well, those were the constitutional laws that permitted them to ignore the statute. So over the next 10 years, we had mandate after mandate after mandate passed against local government. Growth management laws, environmental protection laws, employee mandated benefits, the list went on and on. They averaged about 25 mandates a year. Mandates being defined as a state law that required local government to raise their taxes to fund a state policy. And as you can imagine, the frustrations grew. Now, bear in mind, when we talk about these policies, we're not talking about whether they're worthy policies or not. Of course they are. Everybody thinks you should plan for, comprehensively plan your growth, protect your environment, pay your employees well. It's really, though, a question of who pays for it. And if the state thinks it's important enough for them to ask us to do it, perhaps they should provide a means to pay for it. Excuse me, I'm having a little trouble with my. In 1988, Fred Dudley, then Senator from Fort Myers, and Pete Dunbar, then Senator from Newport Richey, filed the first proposed amendment to the state constitution to limit mandates. The proposal said that the state legislature cannot pass a mandate without a 3/4 vote. Both proposals, the House proposal was heard by the House, the Senate proposal was heard by the Senate. The proposals did not pass. One of the little secrets here in the state legislature is that if they don't like an issue, they may pass it in the House in one version, in the Senate in another version. They never pass the identical bill, but they can go home and tell you that they did in fact vote in favor of the bill, but it just didn't get passed. And that's what they did in 1988. And they also increased firefighters and police officers' benefits, special risk retirement benefits, and it cost local governments about $60 million per year. Well, what happened at that point is that the city officials pretty much exploded. In October of 1988, at the League's annual conference, in October, the League membership authorized us to try to put an amendment on the ballot that would prohibit unfunded mandates, and the League set about gathering the petitions to place it on the ballot. It prohibited all mandates. It did not give the legislature any kind of relief. And we did a full court press. You had city officials were going. You had cities passing resolutions. You had league leaders talking to the editorial board. They were taking city officials from the community with them. We had editorials that were chastising state legislators for their failure, for passing unfunded mandates. I'd like to take a minute and read the first one up there on the top left. These are newspaper editorials at the time around the state, give you an inkling of how the papers were helping us out. Again, as I said, city officials were talking to their local chambers of commerce, talking to civic clubs. This was a full court press. We had resolutions being passed by the city councils, and it was just one thing after another. Now, the other thing too at the time is that the stars aligned. Bob Martinez, then governor of the state of Florida, had resigned as the League president and as mayor of the city of Tampa to run for governor. So we had help with this in the governor's office. He had been through mandates. He understood what they were about, and he didn't like them any more than we did. We also had an unusually strong League leadership team. We had people like, right after Bob Martinez, we had then Mayor Glenda Hood. We had Councilman Larry Durrance from Lakeland. We had Raul Martinez from Hialeah. Jim Noggle out of Fort Lauderdale, Eileen Lieberman out of Lauderhill. Just a great, strong leadership team. Bill Evers was mayor of Bradenton. And the reason I bring this up is because they were afraid of no one. They were not to be intimidated. They were the intimidator. We had city officials wondering out loud whether they had the right representatives in Tallahassee. And by that, what I mean is a couple of them were talking to representatives and saying, maybe you ought to run against you. Just a very, very strong pressure coming from around the state. Literally hundreds of cities were behind us in this thing, and the pressure was rising. I put this article in here, this petition drive to end mandates and gain momentum. You should have been at that news conference. That's Raul Martinez, mayor of Hialeah, then president of the Florida League. And those boxes over his left shoulder are petitions. that we gathered. And he referred to him in his speech many, many times. And as I said earlier, he was a plain speaker and was basically telling people that we were going to pass this petition whether the legislature liked it. Now, the entire time during that conference, Mike Siddick was sweating bullets because he was afraid someone was going to go up and touch those boxes. And the boxes are empty. But that's the kind. But we were ready to get some petitions. Again, in 1989, we have the proposal comes back to the state legislature. Sandy Morton, who used to be a city commissioner of Largo, is the sponsor of the House proposal. Pete Dunbar, the sponsor the year before, has moved over to the governor's office as his general counsel, and Fred Dudley handles the Senate counterpart. We had many representatives on that proposal. They included people like Fred Jones out of Auburndale, Ron Saunders out of Key West, Harry Good, who's now the mayor of Melbourne, he was co-sponsor, Tony Jennings out of Orlando, who later became president of the Senate, Ron Saunders, John Cosgrove out of Miami, Jim Arnall out of Jacksonville Beach. We probably had 50 sponsors on the House. All this work and pressure, it finally paid off. Then President Crawford of the Senate and Speaker Gustafson of the House finally came to the league and said, look, we'll do a deal. We will permit a mandates vote in the House and Senate if you will lay off your petition process. And so after that, Gustafson directed House staff to work with league staff to come up with a proposal that would go for the House and the Senate. Then a fellow by the name of Barry Kling, who was the House Staff Director in Community Affairs, and Jim Wolf, who was the then League General Counsel, did most of the heavy lifting when they worked that bill out. Judge Wolf now serves on the 1st District Court of Appeal. So the bill passed, and we took off and did the exact same thing again. League leaders, along with the city commissioners from various cities, met with editorial boards. Cities passed resolution after resolution. City officials spoke again at civic events, at local chamber meetings. Just one large system after another. In fact, the league was sued by the firefighters union, alleging we were expending public funds in favor of the petition, and we won the lawsuit. We had a victory campaign. The league board authorized the league to spend upwards of $1 million on paid media, direct mail, coalition building, field operations. And at the October conference, we had what looked like a mini convention, complete with delegates, speakers, and the like. And on November 6, 1980, 64% of the people in the state of Florida voted in favor of the amendment. So what does the amendment say? The amendment generally contains five subdivisions. One that restricts substantive mandates, two that deal with financial mandates, one that provides exemptions, and one that permits the legislature to implement it should they choose to. Okay, subsection A, which is the substantive amendment, basically says that the legislature will not pass an unfunded mandate on local government unless it first determines that the law fulfills an important state purpose and unless one of the following conditions are met. Now bear in mind, every time they do them, what we now have in Florida is we have legal mandates and illegal mandates. And the first one prohibits an illegal mandate and says what will make it legal. In all instances, the legislature must determine that it fulfills an important state purpose. The legislature must appropriate sufficient funds to pay for the requirement. Sufficient funds are determined at the time of the enactment. Alternatively, the legislature can provide the local government with a new funding source to pay for the requirement. The new funding source must not have been available for the local government on February 1, 1989, and the city must be able to tap into the funding source with a simple majority vote. Or they can approve the mandate by 2/3 vote of the membership of both houses. Interestingly, this is probably the place where they pass more unfunded mandates on us today because of this one. And frankly, this one was almost a throwaway in the requirements. We literally felt that it would be almost impossible if we set our minds to it for them to get a 2/3 vote on anything. But frankly, for a lot of reasons entirely unrelated to this, and which would probably take another webinar, the legislature has changed so much in such a top-down driven process that it's pretty easy for them to get 2/3. They really try. Alternatively, the law, again, they have found an important interest, and the law applies to all persons similarly situated, including the state and the local government. Now, this is the, excuse me. This is the window that they use to, from two things. If this is an environmental mandate, they can use this as the window to pass it. You know, it doesn't matter if you're a private water and sewer system or a public water and sewer system. If the requirement applies to similarly situated people, it is not an unlawful mandate. Also, this is also the window they use to pass unfunded employee mandates on local government. You know, they say, well, we're gonna increase pension benefits for firefighters, and it's going to apply both to state firefighters and the local firefighters. Therefore, the mandates provision doesn't apply. Or they're going to pass an employee protection statute, and they say, well, it applies to police officers and it applies to the state highway patrol, so the mandates provision doesn't apply. The next condition is the law is required to comply with the federal mandate, and the mandate contemplates that that local government will comply with the mandate. This next article here is an example of this at work today. Some of you may know that the EPA passed numeric rules. What are they called? Yeah, numeric nutrient rules on Florida about a year ago. A bunch of people have filed a lawsuit. They have withheld those rules, and now the state has passed a state rule to implement the numeric nutrient rules. But the state law has to be, the state rule has to be approved by the state legislature. So this will be a perfect example of a piece of legislation that is designed to, quote, comply with a federal mandate, and it specifically contemplates actions by local government. The last condition on the substantive mandate is that it requires eligibility for federal entitlement. That's where your Medicaid requirements and your Medicare mandates on counties come from, that are accepted from the mandates rule. The second section, the mandates amendment, requires a 2/3 vote of the House and the Senate to reduce the authority of municipalities and counties to raise revenues. this provision speaks to authority as the that existed as of February 1, 1989. So you go back to February 1, 1989, you determine the authority the municipalities and counties had. If they try to reduce that authority, it takes a 2/3 vote. It also deals with revenues in the aggregate, meaning that they could remove general authority for you to raise revenues as long as they replace it. It's also arguable, too, that if they removed authority from municipalities and gave it the authority to counties, that would satisfy this mandates provision. Subsection C, which is the other financial provision in the mandates amendment, requires a 2/3 vote of the House and Senate to pass a general law that reduces the percentage of state tax shared with local government. For example, the legislature shares 1/2 of the 5th cent of sales tax with counties and cities. So in order for them to remove that authority, to take that back, it would require a 2/3 vote of both houses. There are exceptions to the rule. First, the revenue, nothing applies to any increases in state taxes enacted after February 1, 1989. So, for example, they passed the 6th cent sales tax. The mandates amendment did not require them to share that with us. Even though that reduced the percentage of the state's tax that they shared with local government. They could increase the base of the sales tax. They could levy the sales tax on services, for example, which in turn would have the impact of reducing the percentage of state tax, but because it was an increase enacted after February 1, it would not be subject to the mandates amendment. If they take away your state revenue sharing during a fiscal emergency declared by the Senate President and the House Speaker, it does not implicate the mandates amendment. And ladies and gentlemen, the House, I think they have probably cut their budget $10 billion in the last 3 years. So there are those of us wondering out loud when they're going to turn their attention to state shared revenues to local government. This exception would permit them to do it. The last exception is when the legislature replaces revenue shared from one tax source with revenue shared from another tax source, provided that the new tax source will be subject to this requirement. An example of that was several years ago when they replaced the state cigarette tax with the state sales tax in our municipal revenue sharing. The fourth section of the mandates amendment provides just straight out exemptions from the entire act. Laws adopted to require funding of pension benefits existing on the effective date of the amendment are not subject to the mandates amendment. If you have, for example, when they increased that special risk benefit from 2.5% to 3%, it happened before November 6, 1990. So if they have to, if you have to increase your funding for that, then it doesn't apply to the amendment. Criminal laws do so. So let's say that they pass a law that places a mandatory penalty in imprisonment for a crime. The fact that that law will cause counties to spend more money to maintain their jails the mandates amendment does not apply. Election laws. Let's say the legislature passes a law that says that the supervisor of elections has to use a specific type of voting machine. that law would not be subject to the mandates amendment. The General Appropriations Act and the Special Appropriations Act. Let's say that your representative or senator is kind enough to find you $500,000 to help fund an arts festival in your community during the coming year. The fact that he cannot get that money again the following year does not implement the mandates amendment. Laws reauthorizing but not expanding then existing statutory authority. I don't know, most of you, I don't know if y'all have been around long enough, but the state legislature used to have a process that they referred to as sunset review. And basically it was a process that they established that required them to periodically review state laws that governed the regulation of professions like physicians or the regulation of various services like insurance. And they would repeal the statute that regulated the physicians or the insurance 10 years out, which in turn would force them to reevaluate it and reenact the regulatory scheme that they thought it was appropriate. Now they don't do that anymore, but that was what that exception was designed to address. If they, reauthorize something, that would not be a new mandate. Laws having an insignificant fiscal impact. The state legislature in its rules has defined that phrase in the aggregate. They say that an insignificant fiscal impact today is 10 cents per the time of the population of Florida. And I believe that that would be about, that comes out to almost $1.9 million, 10 cents times Florida's population. So if a state law cost us more than 1.8 million, less than 1.8 million, they deem that to be an insignificant fiscal impact. And then the last one is laws creating, modifying, or repealing non-criminal infractions. Most of you, for example, get a piece of the penalties for non-criminal infractions cities do. If they were to repeal or decrease the penalty for, say, drunk driving or something, that does not apply. The mandates amendment does not apply. The last section permits the legislature to enact an implementing legislation. As the prompt says, the legislature passed one in 1991. Governor Walton Childs vetoed it. Another one was proposed in 92. It failed, and then things kind of fell by the wayside. Now, interestingly, they are talking about an implementation bill this year, but I'll get to the reasons for that in a minute. If any of you have read the mandates amendments, you can readily ascertain that there was a lot of give and take in getting that bill put together, getting that amendment put together, and there are indeed a ton of issues that arise to the naked eye. Hardly none of them have proceeded through the courts thus far, so we're just kind of left to speculate on how they might affect us in the future. First of all, it's apparent the courts have already held the mandates amendment. First of all, it's apparent from its face that the mandates amendment only applies to general laws. So the legislature can still pass a special act that contains a mandate. As most of you know, the legislature can pass two types of laws: the general law that applies statewide, or a special act that applies to a specific geographical location, like a city. They can still pass a special act that has that places a mandate on you by special act. Another issue that we walk around is the important state interest. As you may recall, in a subsection A mandate, the legislature must determine if it fulfills an important state interest. Now, the courts have already held that if they don't say anything, then they have violated the mandates provision, if it is indeed a mandate. But the question now recurs on what what kind of determination do they have to make? Can they simply state in the text of the bill that they have determined that the act fulfills an important state interest, or must that be supported by some type of tangible evidence in the record that articulates the interest that is going to be served and how this mandate is designed to fulfill the interest? So I've seen instances where this issue almost got to the courts, but not yet. But it's there and it's alive. Obviously, if they could just simply say, "Hey, this fulfills an important state interest," then and that's all they have to do, then that almost nullifies that requirement in the mandates amendment. Another one involves the application of the amendment. The courts have already held that it applies prospectively. So it does not apply to unfunded state mandates that were on the books on November 6, 1990. But here's where the real issue gets us. What happens if a state agency that has authority to implement a law that was on the books on the effective date of the amendment, and they reinterpreted it, and that reinterpretation places has a financial impact on the city. I'm sure most of y'all know, for example, that state law classifies roads on the basis of them being state roads or local roads. It grants DOT the authority to periodically reclassify those roads. So what happens if DOT goes through a reclassification process and drops a bunch of former state roads into the laps of the local government, which in turn is going to increase their maintenance costs? Would the mandates amendment apply to that action? What happens if the Division of Retirement reinterprets fire and police officer pension laws, and the reinterpretation has a fiscal impact? Is that subject to the mandates amendment? That's an issue that's currently outstanding. Another issue is the phrase insignificant fiscal impact. As I said earlier, the state legislature has defined that in the aggregate. They take a look at a bill, they say if it is more than 1.8 million, then less than 1.8 million, it does not have fiscal impact on cities and counties. So they defined it in the aggregate. And frankly, that might be okay if you're looking at subsection B or subsection C mandate, which are the financial mandates, but I'm not sure about a subsection A mandate. As you can see, the way that provision starts, it says, no county or municipality shall be bound by any general law. That speaks in the singular. So to me, it would have to have an insignificant fiscal impact on a county or a city in order to avoid the mandates amendment. I mean, this may sound subtle, but it makes a difference. So, I mean, take, for example, a state mandate that increases police officers' retirement benefits. Well, you probably have 25% of the cities in the state of Florida don't even operate a police department. So obviously it's not going to have a fiscal impact on them, but it may have a dramatic fiscal impact on the rest of them. Or let's say they pass an environmental law that applies to water and sewer systems. Well, only half the cities in the state of Florida operate a water and sewer system, so it could have a significant financial impact on them. But if you take the financial impact in the aggregate, then you can spread it out and call it insignificant. So that's an issue I think that's outstanding, and I personally believe that it applies singularly in a subsection A situation. This issue is an issue that involves the appropriate remedy to be applied when the court has found that there is indeed a mandate. This issue almost got to the courts last year in a case called Atwater versus City of Weston. It was brief, but they disposed of the case on a technicality. They never reached the substantive part of it. But in that case, the City of Weston had challenged the recently enacted growth management law. That law had stripped a lot of mandates off local government, but it had added several other mandates to local government, and they were able to get the circuit court here in Leon County to hold that the bill violated the mandates amendment. So then the question became, okay, now we found the violation, what is the remedy? In this case, the circuit judge voided the bill in its entirety. But you have to ask yourself, is that the appropriate remedy? You know, let me go back just very quickly. Now you see where it says, no county or municipality shall be bound by any general law. What that says to me is that if there's a mandate, the bill isn't void, but a city and county is excused from complying with the general law. So what was briefed in the first DCA was simply that question: if you have a mandate, is the law still in effect? And is it simply that the cities just don't have to comply with the mandate, or they don't have to comply with the bill? Now, bear in mind, this bill removed a lot of mandates from local government. So you would prefer to be able to pick and choose from the bill what you comply with and what you don't. But I believe that's really the remedy. But as I said, it was dismissed on technicality. The issue was brief, but it wasn't. The court did not rule on it. The other issue in that same case is whether the cost of mandates removed in a bill could be netted against the cost of mandates added to the bill. You know, as I said, there were a lot of mandates removed, and there were a lot of mandates added in that bill. So I do know that if you speak to the people that drafted that bill, they will say, yes, you are entitled to net these costs against each other when you're determining whether it has an insignificant fiscal impact. There have been at least 2 instances where significant proposed changes have been made or been attempted with the mandates amendment. One was the Constitutional Revision Commission in 1998. The other one was several years ago with the Tax and Budget Reform Commission. In both instances, there were either substantive changes proposed, or in some cases there were procedural changes proposed. As I mentioned to you in subsection A, it says that a mandate is a mandate unless the legislature has determined that such law fulfills an important state interest. Several efforts were made to change that phraseology to unless such law fulfills a compelling state interest. First of all, that change does 2 things. First, it takes away that argument that the legislature can simply determine that it fulfills the state law, and they've now fulfilled the mandates requirement. So the legislature is not going to be able to do that if you use this phrase. And moreover, compelling state interest is a much, much more difficult burden for the state to overcome. And in fact, most people do not know what the phrase important state interest means. The courts have, they've construed the phrase fulfills a state interest, they've construed the phrase fulfills a substantial state interest, fulfills a compelling state interest. There is no case law that construes what the phrase important state interest means. So by using compelling interest, you would move yourself into a body of case law that you could analyze a mandate on against, and it is a very significant burden to overcome. Other substantive changes, they've tried to increase the threshold from 2/3 to 3/4. We tried to amend the similarly situated language to assure that it only applies when a law applies to both private and public parties, so they don't use that exception to pass up public employee mandates on us. As you've seen, there are a lot of dates in the laws that date back to February 1, 1989. There's been proposals to update those dates. And again, there have been proposals to define the phrase insignificant physical impact. Another proposal that I did not put in there that we've talked about at times was earlier in the presentation I was talking about sunset review of regulatory schemes. There have been discussions about systematically repealing unfunded mandates a couple years out and forcing the legislature to reevaluate that mandate, and in doing so, subject that mandate to subject on the books mandates to the mandates amendment. There's also been these procedural changes proposed. Now, bear in mind, these might not look very important, but they are very, very important. There's going to be 2,000 bills filed in the legislature this year, 1,000 in the House and 1,000 in the Senate. They've got a 60-day period to hear them. Time is very, very important. If a bill gets 3 committee references, just the time will probably kill that bill. So if you place obstacles in the path of someone to pass the bill, it compounds the problem. So, for example, if you had a requirement that the bill contain a mandate contain no other subject, that's similar to the state constitutional provision that says that if you pass an exemption to the public records law, it can contain only that subject, no other subject. So you can't sneak in a public records exemption. Same would apply to a mandate. Or that the bill contain a mandate state with specificity the public necessity justifying the mandate. In other words, make them demonstrate that it does indeed fulfill some sort of public interest. That the bill be automatically referred to a specified substantive committee to be heard. Again, that anything that slows them down might kill it. A requirement that there be 48 hours advance notice before the hearing in the committee, and that a requirement of an economic impact statement accompany all bills contained in the mandate. Those are all procedural things. Those all focus on how a bill is passed. Any one or two of them might present a huge obstacle to a bill that contains a mandate. Where do we go from here? Honestly, the league needs to continue to be active in the courts and try to get favorable constructions of the amendment at any point, any time. The league could embark upon a petition process as we did in 1988. The real problem with that alternative is that it's very difficult to put together a mandates proposal that has material that materially helps us without running up against a single subject challenge. There's no question. I was there in the late 1980s, and I saw the type of effort that we had to put in to get what we have on the books, including its deficiencies. And it is a Herculean effort, a very difficult effort. I mean, it requires that city officials really get behind it. It requires really strong leaders. It requires significant financial resources. I mean, it really requires a fundamental commitment. That concludes my presentation. I will be happy to try to answer any questions, and I do appreciate you very much hearing me out today. I have attached at the end of this presentation the mandates amendment so that you have it. I appreciate you participating. Again, the copies of everything that I've said will be on the website, including this presentation. That concludes today's presentation.